Thank you, Senator Perry. You've been very patient with all of us, I must admit. I'm going to try to focus more on the differences between the Senate bill and the amendments that were passed in the House. I think we've had a lot of discussion over the general intent behind, Senate Bill 4 and all of the issues that it brings up that have been discussed there. I want to start out by saying, that I'm concerned that Senator Taylor, for example, talks about essentially that this bill is necessary because you have all of these murderers and rapists and other folks along those lines getting released. You and I were at the interim committee hearings during the summer for the Senate Border Security Subcommittee discussing these issues. And as I recall, the testimony indicated that all 254 counties were complying with the detainers to the extent that they were being requested by ICE for assistance. There was, of course, the issue that's being brought up today about the sheriff here in Travis County. But even Sheriff Fernandez's policy makes it very clear, and she's reiterated it many times, that she is not, let me put it this way, she is honoring the request with regard to any murderers, rapists, and serious criminal offenders. She's not releasing those people. And certainly, if she's not doing that, then you and I can recall that based on the testimony we heard, none of the other counties were doing it either throughout the state. Wasn't that correct?
It's not 100% accurate, but
why? I mean,
we have
what's
testimony,
not accurate?
and it's the exercise of discretion in that process. And you and I know that it's that discretion that got Sheriff Fernandez on Travis County in the limelight, if you will. She's carved out 3 offenses, which still leaves a whole host of other offenses that you and I would not want perpetrated on any one of our family members. So it's that discretion that this speaks to. And that's what happened when you allow someone to determine what is and isn't the way a federal immigration law.
Well, let me say this. I mean, for
during the interim, we did have discussions, and you, being from El Paso County...
Are you aware that she is exercising discretion to release murderers and rapists and aggravated robbers?
The offenses she names, and I'm sorry if I don't remember every one of them.
Yeah.
Human trafficking, aggravated sexual assault, and murder, or capital murder. Which of what did that leave out?
Well,
a whole lot of other things that you and I don't want perpetrated on us. And it's that discretion that, in my opinion, will prove to be setting up a de facto state immigration system by setting up the offenses that she chooses not to or to enforce detainers. But that's a different debate, different discussion. Specific to SB 4, what are you looking for?
Well, I guess you and I do differ in terms of the testimony that we heard during the interim then. But, one of the issues that you have raised, you said it during the hearing on SB 4, is that this is all about the rule of law. And that seems to be the concern that a lot of you who support this bill bring up, the rule of law. I want you to put yourselves in the shoes of a sheriff or a chief of police that controls a municipal jail, which there are a few around the state. And put yourselves in their shoes, and they've had an inmate that there's been an ICE detainer for. Doesn't matter what the charge is, but there's an ICE detainer, and these ICE detainers, as you know, are for 48 hours. And ICE doesn't come and pick up these inmates within the 48 hours. And the judge is already approved release of the inmate, perhaps even under bail. So who is following the rule of law in that case, do you think?
Well, federal immigration law allows them to keep them for 48, and after that they can be released. So that's federal immigration law. SB 4 didn't change that.
Well, but But I think
So, in the
what
event-
I've been hearing is that they should not release anybody as long as they're under an ICE detainer, whether or not ICE comes over and picks them up or not.
All
And
I'm
so in the
asking-
meantime, as you know,
All
your county,
all SB4 does, let's go back to what SB4 does. Apply the law of the land as it is today. So, in your circumstance, and I hope it doesn't happen, I don't believe ICE wouldn't come get someone that's committed those kind of acts. But in the event they didn't, and she releases somebody post 48 hours, that's federal law, and then it's on the feds.
well, here's where I'm headed
That
with
is
my
the law.
question to you. Okay, that's in the cases of inmates that ICE doesn't come and pick up. And so the sheriff necessarily exercises discretion, not just because they want to release them,
What's the
but there
law?
is something called the Fourth Amendment and the Fifth
So go
Amendment.
back to, what is the law today?
Well, that's where I'm saying.
48 hours, right?
No, but I'm talking now about constitutional, United States constitutional Fifth and Fourth Amendments that frankly trump an ICE detainer, which is merely an administrative request. As the federal courts have pointed out, it's not even an order, a court order. It's not even a warrant. It's just an administrative request, and that's why these federal courts,
Let's be
as you know, have
clear.
been saying those are not
And
sufficient to hold people, and if you hold them, you're violating the Fourth Amendment
this
rights.
has already been asked and answered. Several courts, not all courts, and not all federal courts at the right jurisdictions have ruled some capacity as you speak to.
Right?
Last time I checked, until Congress changes the law, then we have to abide the law, not what court rulings are. That sends an indicator. Maybe things are coming, major changes are coming. But until one, the Fifth Circuit says something to address this, and number two, until the Congress makes changes accordingly, this is the law that we have today.
Well-
But it's a 48-hour detention. Once that's released, if it's a bad guy and that's on ICE, that's a federal problem.
Well, you're talking about the laws that exist today with regard to federal detainers, the administrative rules under federal detainers. I'm talking about the 200 and some 50 and over year U.S. Constitution, the Fourth Amendment and the Fifth Amendment. And so that's why I bring up the rule of law and ask you the question again.
I'll ask-
If you're the sheriff and you know that under the Fourth Amendment you can't hold someone
So,
against the
so
mandates of the Fourth
what you're
Amendment,
suggesting is, and I'm
who's
not...
following the rule of law?
What you're suggesting is that the federal immigration detainer process is in violation of the Fourth Amendment. If that to be the case, let the courts figure it out. So my point is, we apply the law as it is today. If there's concerns constitutionally, the way that's being implemented, that will be worked out through the courts and the judiciary. That's not what SB 4 seeks
Well,
to
I
change.
think that's where we're headed.
that's
I know you
outside
said
of SB
that,
4 scope.
and so I wanted to point that out. And then you were talking earlier about how you trust the police officers to do the right thing. You don't trust the sheriffs mainly from our major jurisdictions, Dallas, Houston,
I trust
you know,
all my
El
men and women
Paso,
in blue, but I also
all of
know
them are opposed to the
that
bill.
is not true. I can
From
name
these
you-
jurisdictions, they all testified against it.
I've got sheriffs that are for it. I've got chiefs that are for it. I've got law-abiding police officers and commissioned police officers that are for it. So the blanket statement that all are for it is just not accurate.
That's why I said
Individual officers-
of the major jurisdictions
But
that
again-
cover more of the population in the state, Senator. That's what I did hear during the interim, as we were talking about earlier. Yes, there were some folks that showed up that represent mainly rural areas that said, we're okay with this bill. But I'm talking about where most of the population is. I'm talking about Dallas, Houston, San Antonio, El Paso, Fort Worth. And so it seems to me that we're giving mixed messages. We want to trust law enforcement to do the right thing and not racially profile and all that, but we don't trust them when it comes to them saying, this is going to make our communities less safe. Essentially, that's been their message. But
Sure.
let me move on to these amendments, okay? let me move on to this amendment. Let's start with the Schaefer amendment. That was House Amendment number 9. And that's the amendment that it seems to me differs somewhat from yours and why I think we ought to not concur here. That's the amendment that basically brought up the issue of lawful detention and being able to allow the officers the discretion to ask about immigration status as long as it's, quote, a lawful detention, right? And I think it goes to what Senator Menendez was talking about. Well, it could be a lawful detention because you have a broken, tailpipe or no light or you didn't stop. Those are all lawful detentions. But your bill, as I recall, and I've got just the section here on it, I don't have all of the bill, in the portion that addressed enforcing immigration law, that's Article 2.251, Enforcement of Federal Immigration Law. In your bill, you made it clear that a police officer could not stop a motor vehicle or go into someone's home to do a search or a business solely to enforce federal immigration law unless there were 2 conditions met. They could do it if under subsection A1 at the request of or providing assistance to appropriate federal law enforcement officers, and we had some discussion about that at the committee hearing, or under the terms of an agreement between the law enforcement agency employing the officer and the federal government, under which the local agency receives the authority to enforce federal law regarding, it says, aliens, immigrants, or immigration. So those are the circumstances under your bill, under the Senate bill, under which these officers could enforce federal immigration law, right? Now, the Schaefer Amendment, on the other hand, doesn't limit it in that way.
The Schaefer Amendment removed the Senate bill language and left it because it is current law today. So it was...
Well, that's my point.
It is current law
that
today.
It removed the Senate bill language and broadened the circumstances under which...
They didn't broaden it. It's currently current law.
Well, I'm saying there's a distinction between the Senate bill and the House bill under this amendment that I think gives rise to concern for many of us, again, that will result, as you said, the courts having to iron this out. So I wanted to point that out, members. Secondly, let's move on with on this. And by the way, I guess I have to say before I move away from this section of the Schaefer Amendment, it is, in fact, Senator and members, going to cause and prompt constitutional challenges over potential civil rights violations. Now, I know you said we're using buzzwords when we say racial profiling or that there's fear out there, but I think other members have already pointed out how these are very real. And you and I know, we've been reading the papers all this session about the disparity in the number of tickets given to African Americans and Hispanics as compared to non-Hispanics or non-African Americans, stops on the roads, different. And then at the national level, I don't need to recount, incidents involving use of force that have been and continue to this day. In fact, I think we hear several of them in the news just today. And so there are some real concerns. I want you to understand that these are not manufactured fears or people using buzzwords to magnify the issue. There are some real problems that we have with the way minority communities get treated in this country. And so that's why you have this concern that under the Schaefer Amendment that there could be these potential racial profiling, as was the fears and concerns over Arizona's Senate Bill 1070. And all it's going to do is just divert more of our police resources.
So let's stop right there real quick. Arizona's been mentioned a couple of times.
Yeah.
This is not the Arizona bill, and we all know
Pardon me?
this is not the Arizona bill. So, again, that's one of the buzzwords, but this has no similarities to where Arizona's bill
Well,
was.
to the extent that...
With one exception.
Yeah.
The one provision that was upheld at the Supreme Court level in Arizona bill was the fact that an officer could inquire.
Right, right. But the court was very careful, as you know, to say that we can't make a judgment on this point because we don't have on the record any evidence that this is the case.
I just want to make sure.
But that didn't mean that it's not happening, okay?
No,
it was in that case where they didn't have the evidence.
I'm not naive to think that it doesn't happen. It'll happen with or without SB 4, unfortunately.
You're saying it will happen?
I'm saying I'm not denying that it doesn't happen. With or without SB 4, the circumstance happens. But Arizona's law verified the fact that an officer has the right to inquire. But to use Arizona is inflammatory because of all the other negative connotations. So that's where I'm going to. We have an obligation, an accountability, and a responsibility to depict what SB 4 does and does not do and not inflame what it might do.
Well,
thank you.
What other questions? We disagree on that. Sir? Let me go to another amendment. Now, this amendment is interesting to me, frankly.
Which one?
This is House Amendment number 64 from Representative Olivera, okay, a Democrat. And this amendment somehow got accepted over on the House side. It basically provides a presumption that possessing a Texas driver's license or other identification means that a person is legally present. And the local jail is not, and I want to emphasize under that amendment, the local jail is not required to comply with ICE detainer requests for that person. You and I know, members, driver's licenses are not an immigration document. I wish Senator Berger were here, and he knows that. And so what we're getting at here is a situation where you have.
So do you not want that amendment?
Well, no, this is where I'm
okay,
at.
That's what I thought.
Any state law that authorizes, now listen to me, any state law that authorizes a local or state entity to make an independent assessment of an individual's immigration status may also be deemed to be an impermissible regulation of immigration and preempted by federal immigration law. This amendment that was not in your bill, this language, it seems to me, is opening up yet another area for, as you say, for the courts to have to resolve down the line. We know, members, that immigration law generally vests authority in the Attorney General and the Department of Homeland Security to administer and enforce all laws relating to immigration and naturalization, including determinations regarding the immigration status of individuals. Now, I want to just remind you, and you'll recall, the Farmers Branch litigation up there by Senator West's neck of the woods. Now, that was a case where the court suggested that the law was also preempted, the local municipal law, because it required private persons and city officials to make independent judgments regarding the immigration status of potential renters instead of verifying status with federal authorities or under federal guidance. So we're doing the same thing here under this Olivera amendment, it seems to me. We're saying if they have a driver's license in the jail, there's a presumption that they are here legally, essentially, and that the jailers can't detain them even in the face of a nice detainer. That is a major departure from your bill. Wouldn't you agree?
So it addresses exactly what Senator Mendez was talking about, and Senator Whitmire, Dean Whitmire, that if you stopped and you can produce that, I'm assuming that the officer has the discretion to say that's enough, and that's not in violation. That said, your scenario is no different than a local jurisdiction picking and choosing what offenses determine an appropriate detainee or not. that too can be inferred to creating a de facto state immigration. So that's a discussion, again, for the courts to figure out if they need to. But on that issue, that was in a different scenario. Lawful detainment's occurred. Here's what I have as my license. It shows I have a physical address somewhere in the state, I assume, possibly, or in the country.
Yes, sir.
And it has their birth date, it has their identifying information on it. At that point, it's verified. If they can't determine that whether or not that's enough for whatever situation is at hand, the officer has that discretion. So I don't think it creates another de facto immigration
Senator,
issue.
with all due respect, maybe I was not clear. Maybe I was not clear because you're talking about, again, the situation where people are stopped and the officer has discretion. I'm talking about somebody that is in detention, is in the jail. The concern that Senator Taylor has and that you have. These are people that are in the jail, and this amendment says that if they produce a driver's license, then the jailers are supposed to presume, based on that driver's license, that they're here legally. And they're going to release him even if there's an ICE detainer.
Do we issue licenses to illegal undocumented today in this state?
Pardon me?
Do we issue Texas driver's license to illegals in the state today?
Not in this state,
So
but California does, and a few other states do.
I'm a Texas
and they can
senator.
be here in the state,
I'm a Texas
in jail.
senator. So I'm a Texas senator. So I'm going to make the premise that that was amended based on the fact that if someone sits with a Texas license,
I just said
then that
license.
is defect. So
Okay? So what I'm saying here is that there's a difference between your bill
there is.
that we pass here in the Senate and the House bill as a result of this amendment, which is another reason in my mind why we ought to go to conference to clarify these things. Let me mention one last amendment here. And there were many, as you know. There were over 100 amendments that they contemplated, and they ended up, limiting the number. But I wanted to focus on the ones that seemed to me that raised concerns. The Rinaldi Amendment, Amendment number 10. Your bill did not have a civil process for removal of local officials. And I have serious concerns with that because the Rinaldi Amendment in the House bill does have that provision in there. And so the concern basically is that you've got elected officials, and you work with them day in and day out in Lubbock, and I do too, in my district, all of us do. These people were elected by the voters. They swore to uphold the law just the way you and I do. And under this legislation, there's some murky areas, right? There's some murky areas. Because, for example, we use the word, that if an entity or an elected official endorses some policy, written or unwritten, that prohibits officers from inquiring about immigration status, that they are in violation of this bill. And so it seems to me we are putting local elected officials under this cloud, under this threat, that because they are exercising their best judgment in trying to uphold the law that they swore to uphold, that they are now all of a sudden subject to being removed from office. Does that not concern you?
My understanding,
you didn't have that in your bill.
My understanding is,
and now it is.
My understanding is the government code currently allows to have the removal of an elected official, so that just basically incorporates that.
Well, it does, and I dealt with it as county attorney for almost 20 years because I had the authority to remove people, and it specifies, only 3 grounds under which elected officials can be removed. And so removal of elected officials is rare. You got to go through this whole process, right? But what I'm saying here is that this additional ground, based on a bill that has some vague areas, unduly threatens elected officials being subject to removal.
SB 4 is really...
In spite of what the voters wanted in that position.
So we're not changing law. It's already current law that you can remove. Second thing is, I'm very clear on where SB 4, what its intent and purpose and the way it drafted is. If there's any ambiguity, it might be in the federal system. That's a different issue. But on this matter, on SB 4, I think it's very clear what the intent is, and that's to have local jurisdictions apply the law as it is today, without discretion of offenses, without prohibiting frontline officers that have taken an oath to uphold the law, telling them they can't really do what they swore an oath to do.
Yeah.
It's all of those factors that build into SB 4. I hope that we never have an elected office removed for not doing this, because it would probably come at the expense of some very tragic, heinous crime committed upon a citizen that violated this rule from that jurisdiction. So I hope we never see the day that we have to have a local official removed under SB 4, because it would come after someone has probably had a loved one killed or lost to an illegal criminal released.
Well,
So that's, we can talk about, again,
but
hypotheticals, but I hope that
just,
we don't
on
get
this
there.
point, let me just conclude with this, Senator Perry. Don't you think it's rather harsh to tell the prosecutors, the district attorneys, the county attorneys, the criminal district attorneys, these are the people that are charged with prosecuting and enforcing our criminal laws, and the sheriffs and the constables, the very people that are supposed to protect our communities and make us safe from the criminal elements, to put this cloud over them and say, if you, for some reason, under this bill, are construed to have supported some policy that was unwritten because you exercise some prosecutorial discretion, you are now subject to removal,
So,
regardless of what the voters had to say about you being in office.
Prosecutorial discretion should never endanger the safety of the community in which
Right.
they're elected to. So that's the first thing.
Wait.
But it is no more harsh, to use your word, it is no more harsh and actually unfathomable, unconscionable, and I don't have a word to describe it, to look someone in the face that has had their loved one killed by someone that, had they done their job, would not have been on the streets to have killed that loved one. So that is the absolute harshest of situations that I cannot even hope I would never, ever imagine. So I can compare harsh if you want to. It's harsh to go and explain to someone that had a sheriff or a chief or someone, a commissioned police officer, done their job, that their loved one would still be alive today. That's harsh.
Well,
With that, any other questions?
Look, I just want to close with this. You said several times, we'll just leave this up to the courts, basically, is what you're saying.
No, I'm not.
Down the line.
That you're putting words, and I want to clarify that. I don't believe that there's anything in here that needs to be cleared up with the courts. In the event that there is something that is outside the purview of a legislature, it will be handled. I didn't say there's anything in here that's going to the courts. But you ask questions about this or that, that is jurisdictional. We have a separation of powers for a reason. You know, legislature, judicial, executive. And I know where my role is, and it's to make laws. And I make laws and hopefully to protect the public and to promote public good. I believe SB 4 is part of that. You and I disagree with that. But anything in that bill, as if all pieces of legislation that we have, there is always that possibility that judiciary may want to get a look at it. And there's nothing in here today that I think is going to fall short of constitutionality. I try, I think we all do, not to make laws that are unconstitutional on their face. So there's nothing in here that gives me pause or concern. But am I naive to think that it won't be challenged? It's possible. But just like probably half of the legislation we do here, that's a concern that we have to live with as lawmakers. Anything we do here is challengeable. So I don't want to mislead, and you've said it a couple times. I'm saying leave it up to the courts. I'm saying we are supposed to leave up to the courts any challenge that may arise on legislation. That said, SB 4, I believe, and my colleagues believe, have met the muster of constitutionality.
Well, we are going to find out, members. I think we're going to find out very quickly, as we have found out on other things as well. So I think that there are significant differences between Senate Bill 4 as passed by the Senate and by the House. And the whole reason for standing here and bringing some of these amendments to our attention, members, is to say that it would be productive to have a conference on this bill to iron out some of these additional factors that were brought into by the House, and as you all know, it was chaotic over there. It's already been mentioned. And so that's the reason why I'm opposed to your motion to concur, and I would urge the members to vote against the motion, and let's go to conference on this bill. Thank you, Mr. President.
Thank you, Senator Rodriguez.